Our speaker today is Chris Cohen, an experienced local administrative law judge. You'll find out what they do. Today he's going to provide an overview of the various court systems that impact Illinois residents. And in doing so, the hope is to demystify the types of cases each court handles. I know we all listen to the news and they'll say this court did this court did that, and that one did this. And I think many of us, I'm not sure, but I know for me, well, who's that? Which court is that? What do they do? So hopefully we'll have some answers to those questions. So with that, please welcome Chris Cohen.
Thank you. Good morning. My name is Chris Cohen. I'm an administrative law judge, hearing officer, and I currently work for two locations. One is the city of Des Plaines. I'm their municipal adjudicator or administrative law judge, and I also do it with 13 other judges for Cook County. I'm not a black-robed judge like this gentleman, one of your members right here in the front. But I'd like to tell you about some of these different courts. They're confusing because in a federal system, each state can call their people whatever they want to call them. So I'd like to first, Jill Becker, can we pull this up here just a little bit so I can see the bottom one? Yes. If you had a ticket or you saw somebody get a ticket for parking in a handicap spot and it went to a city of Chicago where they have red light cameras, or the Des Plaines where I am, or some other place, that would be the city administrative court. And if it's appealed, it goes to the first level of the black robe judges, which is the county circuit court. You have the right to go to the Illinois appellate court, and you don't have a right to go to the Supreme Court, either Supreme Court of the state or the federal government. But if you do, that's the chain. So I'd like to now turn to the fourth page here, just to start. In Cook County is very different than, I'd like to contrast it with New York. In New York, there are 5 counties in one city, and in Cook County, there are 127 cities in one county. So the court system for this county is much bigger than any of the court systems for New York, because they're all chopped up into 5 different divisions, one for each of the boroughs or each of the counties. So just to start with, this is something that, how many of you have had any contact with any court anywhere? A number of people. Okay. Let's assume that we're talking right now about the Cook County courts. The Circuit Court of Cook County of the state of Illinois, the state has 102 counties, but we only have 25 court systems, one for Cook County, and in some of the smaller counties, they're added together and they have one circuit. So we have a total of 25 circuits or divisions and the 102 counties are divided up into those 25. But the court system in Cook County has 400 judges, which is gigantic, a very large number of judges. And they serve the 5.2 million people who are in Cook County, or people who do business in Cook County. And as I mentioned before, in Illinois, any party has a right to appeal a decision to the circuit court or to the appellate court, but not necessarily to the Supreme Court. In very important cases involving the Constitution of the state of Illinois, if somebody files a case in the trial court or the circuit court, the beginning court, they can jump over the circuit court in some cases if the Supreme Court allows them to do that. When the cases are appealed, this would happen in any state from the trial court, whether in Cook County it's called a circuit court. When they're appealed, they don't relitigate the facts of the original trial. They litigate the law. That we have a trier of fact and a trier of law. In a case where there's no jury, the judge would be the trier of fact and the decider of law, or the trier of law. And where there's a jury, the jury is the trier of fact to see whether the event occurred, whether somebody slugged somebody else, or I heard a terrible story this morning about somebody being thrown over a bridge, and somebody has to decide whether that fact occurred. And then the question is, what's the law that would be applied to it? In the appellate court in Illinois, the trial court is one judge. In the appellate court, there are three judges, and it would take a 2-to-1 majority for one side to be decided. Now, I'd like to go back to the first page and just give you a little brief summary of the Illinois trial court system. I've numbered these here to make it a little bit easier because it is confusing. Number 2, the court of last resort. In the United States system, it's called the Supreme Court. We're used to that. We've seen activity and we've seen them do things in the last week. In the state of Illinois, the highest court is called the Supreme Court. In Wisconsin, where I've practiced, the highest court is called Supreme Court. But in New York, the lowest court is called Supreme Court. I hope the people in Zoom can see this. The lowest court, the trial court, they just decided to call it that. They call it the Supreme Court. And the highest court, instead of Supreme, is called the Court of Appeals. And so where you saw the case with Judge Mershon and we've been just reading about that, the former president, that was done in the Supreme Court, even though it's the lowest court. In the federal system, we have two systems. One is the federal system and one is the state. So this federal system applies. And depending on what state you're in, one of these three would apply. And if you're in a city, at least in Illinois, these municipal ordinance cases would apply. So let's look at row number 2. How many people know how many U.S. Supreme Court justices there are? 9, exactly right. And the state of Illinois, how many justices of the Supreme Court are there? 7, exactly right. And how about, this is probably a little farther away, but I've spent a lot of time there. How many judges in the Supreme Court of the state of Wisconsin? There's 7. So the highest court of the country has 9, and these other 2 states have 7, and the Court of Appeals for New York is a completely different animal, just to confuse you, but at least I'm trying to give you a little bit to help you understand some of the things in the news. The title of the judicial official in the U.S. Supreme Court, what's the title of that person?
Justice.
Justice, exactly right. And in the state of Illinois, Justice, right? And the state of Wisconsin, Justice. And in the Court of Appeals, it's a judge.
Injustice.
Very, very good. So the point I'm trying to make, which is probably obvious, but each state can decide its own system. There was a time, just the way lawyers, how many people are lawyers here or have been lawyers? Well, in medicine, assuming there's a God is deciding what the rules are, and if you can figure out what they are, great. Doctors and other people try to figure them out. But with law, the lawyers and the legislators can make up the answer. And there was a guy during the Jimmy Carter administration who was named Alfred Kahn, and he was the chairman of the Council of Economic Advisors. This is a definition question. And Jimmy Carter had 24% interest, and the question was, the newspapers were all saying, are you going to be able to win this election because you've had a recession? And he said, in my administration, we don't have recessions. And so they asked, the reporters got the mic and they came to Alfred Kahn. He went into the White House and he came back and he says, Dr. Kahn, are we having a recession? And they said, what do you mean? Well, a recession by the economists is defined as 2 quarters with downturn in GNP, gross national product. And so he didn't want to say, yes, we have a recession, but he says, we can define things the way we want to. And he says, well, what do you call 2 quarters, 6 months? And he says, I call it a banana. And then they ask him, have we had a banana? And he said, yes, but he didn't want to be criticized by President Carter. So that was the way he handled it. In any case, the point here is that each state can name its judicial system the way it likes. I had thought about, in honor of Bob Dahlberg's extracurricular activity with his radio program, to call this federal, state, and local adjudications and all that jazz. But with the appellate courts, line 3 here, in the United States, there are 13 courts of appeals, 13 different ones. The country's divided up. I'll show you that in the next page. With the state of Illinois, they've divided up to 102 counties until 5 appellate districts. So depending on where your trial was, if you're at DuPage, you go to a different appellate district than if you were in Cook County. And in the state of Wisconsin, that's the appellate court. And you can see here the definition of the appellate court in the federal system is called the Circuit Court of Appeals, whereas the appellate court in the state of Illinois is called the appellate court instead of the Circuit Court of Appeals. And in the state of Wisconsin, the appellate court is called the Court of Appeals. So it's a little bit confusing, but the words all have appellate in them. So when you read a story, you can see that. In Illinois, an appellate court justice is called a justice. And in the United States, the 13 circuit courts, those justices are called judges, just the way they're defined. Speaking of the 13 circuit courts of appeal, I'd like to go to page 3 just for a moment. We have some great IT experts here, I see. And the 7th Circuit Court of Appeals takes, if there was a Milwaukee case or an Illinois case or an Indianapolis case, if it's in the federal system, the appeal would be to the 7th Circuit. And who knows where the offices of the 7th Circuit are? I couldn't hear you. In the federal building, there's both. If you saw the case about Ed Burke, he was tried in the trial court in the federal building, but also in those federal buildings is the Court of Appeals for the 7th Circuit. So those are the circuits, and there are 11. And then we have 2 additional ones, one for the District of Columbia, and one is the Federal Circuit. So these 11, the appeals, number 8 here, it has appeals from Minnesota, Iowa, Missouri, Arkansas, Nebraska, North Dakota, and South Dakota. But ones from the District of Columbia, because there's so many government agencies there, go to number 12. And number 13 handles certain specific cases like intellectual property, patent law, trademark. Well, that's where the 13 courts of appeals are. And I mentioned on the first page, the appellate court for the state of Illinois the state's broken up into 5. It's not important to know how many there are. I'm just trying to show how it's difficult for people to follow this unless you have a cheat sheet like the one that's in front of you. The trial court, if we can go to page 1 again. Thank you for being able to go back and forth. So we saw the court of last resort, number 2. We saw the appellate court, number 3, and the trial court. The trial court, Ed Burke, the alderman in Chicago, was tried, is called the district court. There are 94 districts in the United States. The United States is divided into divisions called districts. And each one has a district court. And if you see people who are, you're watching a crime story, somebody was murdered, that would be in the circuit court of Cook County, not the district court, because that's Illinois. And it's the same word in, for example, Kenosha County or anywhere in the 72 counties of Wisconsin. It's called the circuit court, same word here. And as I pointed out before, the trial court in New York is called the Supreme Court. And these people are called judges, except you saw in the case with the former president, you saw that Justice Mershon was called justice instead of judge, just because that state did things differently. Now, how many of you have had contact with an administrative law judge? Several of you. An administrative law judge is not somebody in the black-robed judges system. Some, for example, are people who deal, administrative law judge, with disability and whether your neighbor can get disability benefits. That's one kind. I'm another administrative law judge, completely irrelevant to that one. And I do ordinance violations. Northfield has one, although they allow Glenview to do their cases. And Glenview has a municipal court, and Des Plaines, where I am, has a municipal court. So there are administrative law judges. This last week, the U.S. Supreme Court ruled on something called the Chevron doctrine. And the reason I mention that is because these alphabet agencies are ones that the Supreme Court last week reduced their authority. So some examples that you may have heard of are the Environmental Protection Agency, the Federal Aviation Administration, the Federal Trade Commission, the Federal Communications Commission, the Securities and Exchange Commission. And those courts, at least up to last week, when they had appeals from them, when they had trials, whether somebody should, a company or a person should be in violation, like Martha Stewart. Remember, she had a case of insider trading. If you do a case and if it's in in front of the administrative law judge, the appeal would be not to the district court, but it goes to the Court of Appeals and then to the U.S. Supreme Court. To go to the Supreme Court in any of these states or the federal government, you have to say, "Mother, may I?" You have to ask permission. It's called asking for a writ of certiorari. So you have to ask permission. So just make sure that you know, and I think most of you do, you don't have a right to go to the Supreme Court. You have to ask permission, and if they think it's not important or they don't like it, they don't take it. I'd like to give you some examples I gave you some examples of federal administrative courts. At the state level, I've been in unemployment compensation administrative law judges. That's where we say this person was fired or laid off and therefore they get unemployment benefits, or they quit and they don't get unemployment benefits. So I'm just giving you an example. If somebody says that the physician improperly treated you or improperly treated somebody else and we ought to yank his license, or like that doctor in Michigan who was taking advantage of the female gymnast, that some state agency, in that case Maryland, but this is Illinois, would yank the person's license and take their rights. And those are examples also in Wisconsin and in Illinois. Of course, we don't do the Securities and Exchange Commission or the Federal Communications Commission. So stop there just for a minute and see if there are some questions there, because I like to, when I'm in the audience, see if people can help translate what I'm saying. Yes, in the back there. Yes. Just a minute. We need to, your colleagues in the Zoom need to
Okay.
be able to hear.
My only experience with the court system was I contested a ticket. I was ticketed for going out of my lane, and I took photographs, all kinds of things, and I went to the court. Now, which court is that? If in Chicago, I had to go to Chicago, and what court handles those? If you want to contest a ticket, what is it?
A black robe.
I think he did.
Yeah, well, that would be the circuit court where you went, although it's conceivable, but it doesn't sound like that from a law judge like me. In Cook County, there's and so many judges that we have 6 districts. District 1 is in the Daly Center. District 2 is Skokie. District 3 is Rolling Meadows. District 4 is Maywood, where I have a little courtroom. District 5 is Bridgeview, and District 6 is Markham. Okay, you had a question?
Cook County has another layer of judges called magistrate judges. They are elected from subcircuits. They're not elected from, we have judges elected from subcircuits. And then we have magistrate judges who are elected by the circuit court judges and serve a term. What is it, Ron? How long is the term of the magistrate judge?
Associate judges.
Associate judges. And they don't have to run for re-election. And many of the judges really feel strongly that that's a great asset to the county. The judges are not, they are black robe judges, and they get to hear all the same cases as circuit court judges and have the same jurisdiction, but they don't run for election.
Well, they don't run for election for the voters, these associate judges, but they run for election. And who knows who elects the associate judges? This is pretty much in the weeds, but it's a great question. The circuit court judges elect the associate judges. So we have 3 different ways to pick judges. One is the judges run countywide. That's one, and you get to vote for, there's a list of them. The second one is some judges, we've divided the county up into 18 subcircuits or 18 districts, and you can run for us from a subcircuit instead. And so that's a second way. The third one is the one that you very impressively were able to negotiate there, and that is the associate judges, and they have almost the same jurisdiction, you're correct, but they are selected not by the voters, but by the 300 or 400 judges who are the circuit court. So that's absolutely correct. And but they do have to run every 4 years. They almost never get defeated, but they have to run. And by the time the 4 years, they've gotten to be really good friends with their voters, who are the other judges that sit in the courts with them. But you're absolutely right.
The Supreme Court has taken away the power of the FCC, SEC, as you mentioned. What are the consequences of that? What's going to be the change and what's going to be the difference?
Well, that's a good thing. The doctrine that we had been living under for 40 years is called the Chevron rule. That's the name of a case. And it said that the courts, the Supreme Court and the courts of appeals, should give deference to the expertise of each one of these commissions here. They're usually frequently have 3 members, and they're people who just specialize in one topic: communications and television and radio stations, or Federal Trade Commission. And now, last week, you're absolutely right, the Supreme Court said, we're not going to give deference to those. And so, and the theory of the court was that Congress should have told them what to do. We're a country where we're a republic, and we don't want agencies, the deep state, we don't want agencies going about and making rules and deciding on things unless Congress, the people that we voted for, decide on them. And the problem is, on the other side, that if Congress passes a law, things change, whether it's AI or it's communications frequencies, and Congress doesn't always get around to spelling out every jot and tittle of the law. And so the agencies were doing those things. And the Environmental Protection Agency was saying when you can have smokestacks and how many particles can go up it, and we're not going to be able to do that probably under this new rule, because the experts in the EPA were making rules and deciding on how many parts per million you could have. And this rule says the overruling of the Chevron case means that we can't use their expertise now unless Congress told them what the rule was. They were making rules themselves.
Where do the probate and guardianship courts fall in the Illinois system?
Probate and guardian support. That's a really good question. The Circuit Court of Cook County, let's talk about that one, is divided into different units. One would be the ones that take care of guardianship and wills and estates. Another one would be criminal cases. Probate court, exactly. Thank you. And another one would be automobile accidents and contracts. Another one would be asking for injunctions to stop things from happening. I was involved in one case where a boy was dying and his parents had different theories about what should happen. He was swelling up. He couldn't talk. He was blinking yes and no to things. But one parent says, life is so important that no matter how miserable he is, he should be given the maximum amount of life, so don't pull the plug. And the other one says, this is our son, and we can't allow that to happen, and we should stop the pain. And so that's not a case about money. It's not a case about wills. It's not a case about trusts or estates. That would be a chancery case. So we have a group of judges that hear those cases and chancery. Did I answer your question?
I think so. So guardianship falls under chancery?
No, guardianship would be in with probate
With-
and the other cases like that. We do have a guardian for Cook County, which I haven't gotten into, but yes, we have a guardian that takes care of cases like that. Was there another question?
Yeah.
All right, he's gonna bring the mic around. I think there was one here. I don't see him.
Where does the small claims court fit in?
The small claims court is in the circuit court, and it would be one's, it's really not a separate court, it just is a separate jurisdiction. If the case 25,000, that judge who hears those hears lots of smaller cases. Many times the people are self-represented. They didn't hire a lawyer. So you have to have a judge who is respectful of people who aren't know all the rules. You can have a lawyer there. And sometimes if somebody is suing a landlord or a luggage company, if they broke your luggage or something like that, the company that's being sued would have a lawyer oftentimes, but the person who's doing the suing, it's not worth that much money to go to a lawyer and have the lawyer take a percentage. So small claims would be in the Daily Center. Good question. Yes.
First, I do want to point out that the associate judges in Cook County are appointed by the circuit court judges, and it must run with the circuit court judges every 4 years for retention.
That's
but
true.
Only with the circuit judges. The circuit judges, however,
6
upon
years.
running for retention, must get 60%.
That's true.
Yes, to retain their position as a circuit court judge. I'm a retired circuit court judge.
Well, you're
I wanna
absolutely
ask-
right.
I want to ask you, what do you call the bankruptcy court judges in the federal system?
That's the magistrate. I think that's
Call
what
them bankruptcy judges.
Yeah, but
the magistrate
Are
is
they-
bankruptcy judge.
will you categorize them as an administrative judge or as a judge, non-administrative judge?
That's a good question. The question here
From the
is,
Bankruptcy court judge go to the district court in the federal system.
that's true.
Oh. In case you're interested, decisions of the bankruptcy judge go directly from the bankruptcy court to the lowest of the federal courts, the district court. You're entitled to an appeal. You're entitled to an appeal from the district court to the Court of Appeals. And you're also entitled to an appeal from the bankruptcy court to the district court. You are not entitled to an appeal to the Supreme Court without getting certiorari.
That's true.
I also want to point out that associate judge hears limited cases, but associate judges are frequently appointed or designated by the Supreme Court to have the same jurisdiction as the circuit court judge. And I have to tell you that many of the associate judges, in my opinion, are a lot better than the circuit court judges. But there's various reasons for that.
Say that last sentence again.
The reason they're better is because they're selected by judges and not the public.
Yeah. Well, this is an interesting debate that we have politically, and that is, should judges be picked by some allegedly knowledgeable body, or should they be picked by everybody in this room and all of the public? And so some say we want merit selection, and some people say we don't like that because the large law firms will tend to have a say, and other people say we want merit election because we want the public to do the picking. And some people say If the public picks, they don't know any of these people, and therefore there's a debate. Yes, what was your question?
That was my question. I think everybody, when we are asked to vote on judges, we don't know any of these people. And all we know is some organizations, though, put out a list of recommended judges for, is there a better way to do any of this? You already commented. Look it up in the papers, put the Bar Association recommendations, and you'll have a little better.
Yeah, I don't know if everybody could hear that, but
There are bar association recommendations, and some of those bar association recommendations you have to look up in
That's
order
true.
to see. Some of them, the American Bar and the Illinois Bar sometimes have those recommendations that are picked up by newspapers, but there are other bar associations that you have to look up.
That's
Right.
true. That's true. Yes, yep. Is there a question from the Zoom?
Hi,
Go ahead.
I'd like to know where immigration falls under. Immigration judges, what, are they under the circuit court? Are they in the
I
federal
couldn't
court?
quite hear the beginning of the question.
Where does immigration fall under? Immigration judges?
Yeah, who wants to answer that question? Where are the immigration judge?
Immigration courts.
That's an interesting one. These judges here, it's federal. These judges here are Article 3 judges. They're appointed or chosen because of Article 3 of the US Constitution. But the immigration courts are slightly different. They're courts, but they're not courts. Correct. They're administrative courts. And you remember when when Senator Sessions, the Attorney General, was there, and he took away a lot of their authority because, or he made definite rules, and he was able to do that because they're not judges under the Constitution.
Right.
Yes.
Question from Zoom.
Okay.
Tell us how you became a judge. What was your, what road did you take to becoming a judge? And then also, what checks and balances do you have and might there be in general about judges? Knowing that that's a big question and every jurisdiction might be different. But in general, how did you get to where you are? And what is the checks and balances on your performance?
This last year, I've been the chairman of the Administrative Law Section Council of the Illinois State Bar Association. One of the things I've complained about is there actually aren't really any checks on the kind of hearing officer or judge that I am. Our boss, we're contractors. So any day if somebody says, I don't like you and we're just not going to schedule you for any more cases, that's the end of it. Or if somebody wanted to be political and said, we didn't like the way that you did this, or you found too many people innocent, there's no rules that can, we do it on a case-by-case basis. Now, that's not true. When I was an unemployment benefits judge, I was an employee of the state. But where I'm doing it for the city of Des Plaines, I do it 3 days a month. And people come in a courtroom like this, and we decide the cases. But the mayor or somebody, if somebody new gets elected to be mayor, they can say, I want this lady to be the judge instead of you. And they can do that. So, and we are not, these judges are under the Supreme Court. These judges here, the black robe judges, are controlled by the Supreme Court of Illinois. We're not controlled by anybody but the mayor, and that's the executive branch. That's different. How did I get appointed? I got appointed the mayor in 2011 in Des Plaines. Thought I did a good job in my past roles, and he appointed me, but it was what you would call, in effect, patronage. I wasn't paying him anything for it. It's not that like the old Mayor Daley, but it was, that system has been outlawed. But it was, he got to pick who he wanted And when the new mayor came along, he got to pick somebody else instead of me, but the city council overruled him. So that's a little bit of an answer to how that happens. Yes.
Yeah, this question goes back to the guardianship. Help me understand it. A long time ago, I heard of a case where there was an elderly individual, had no friend, no family, no descendants, no children, completely isolated and alone, and was failing and needed help and had substantial assets to support this. And the way I understand it is an outside individual was appointed, the guardian, and had the responsibility to take care of this person. And on the demise, the assets of the individual went to this appointed guardian. Do I have this wrong, or is this a process that exists? And can you elaborate a little bit on it, please?
Well, I haven't practiced in that area, but what happens frequently is they have to have somebody to take care of all of the paperwork in the estate, and the judge in the case oversees it and decides whether that person is doing the right thing. And the judge, let's take the worst case, that the person was doing something that he shouldn't have done, or he was racking up too much time to be paid and that money came out of the estate. The judge should oversee that and stop that or pick somebody else. I'm not sure if I'm answering your question.
But the person that's appointed as the guardian, how does that happen? And who are they? And I understand they're supervised by a judge.
Well, the judge will do the picking, and the judges have a list of people who are said to be capable of doing this kind of work. Doesn't mean they always do it right, but the judge can pick somebody who's his friend or who's on this list. In the case of election cases, just to use that as an example, when you've seen people in the grocery store hand you a petition and say, would you please sign this so I can get on the ballot? Well, somebody has to hear those cases, and I hear those. I'm one of 34 people who hears those cases, and we do that at one point every 2 years. And that's another kind of case like this. And the election board, for example, then they get to overrule us, then it goes to the circuit court. So
I believe that he's looking for that the judge, the administrative judge, would have to approve the expenses of the guardian ad litem of the person who is assigned to the case.
That's true.
And they would come with their expenses to the judge in order to have those expenses reviewed and approved for that guardian to be receiving repayment. I don't know if that
is that responsive to your question. Okay.
Okay, I'm sorry.
Are there any formal requirements that judges need? Certain courses in college or certain background, perhaps as a lawyer, or requirements to become a judge?
The question is, are there any requirements to become a judge? And the answer, the first one is the most obvious one, that you have to be licensed in that state to practice law. And the Attorney Registration and Disciplinary Commission, which disciplines lawyers, you just saw last week. I'm just trying to relate this to things you may have seen in the paper, but you saw Rudy Giuliani, his license was taken away, and he can't practice law now in New York. So the first thing is you have to have a license, and you have to take whatever courses the law school that you went to said you need to take, and there are accreditation bodies that tell the law schools what they think the rules are that they need to have so that you can get accredited. And if you're accredited, then you're a licensing body. In Wisconsin, it's called the Office of Lawyer Registration, but in Illinois, it's called the Attorney Registration and Disciplinary Commission. That's the body that licenses lawyers.
So if you have got your license in Wisconsin, can you become a judge in Illinois?
I am licensed, for example, let's use me as an example. I'm licensed in 3 places, the District of Columbia, the state of Illinois, and the state of Wisconsin. And how did I get those? To pick up on your question about how do you get to be a judge, this is a question, how do you get licensed? Some states like Arizona and California, so many people want to go there that they won't let anybody from another state go there and they pass the exam in that state. But in my situation, pardon?
Microphone. But you have to take the exam in all of those states?
That's where I was going. No, I didn't have to. His question was, did I have to take the exam in those states? Because Wisconsin has a treaty or an agreement with Illinois that if Illinois will allow people in Wisconsin who've passed the bar there to come to Illinois and be licensed here, then Illinois will allow people the other way. It's called reciprocity. So in the case of, I'll tell you just a little personal story, but in the case of Wisconsin, I paid money. They looked at my credentials, and 2 things happened. I had been teaching at, was it Loyola? No, it was Paul. I was teaching some courses. And at the time I was teaching, I was called an adjunct professor. But 20 years later, when I applied, the young said, Mr. Cohen said he was an adjunct professor. Oh, we don't have adjunct professors because they changed the title. And it was a lecturer. So they said, we not only are not going to allow Wisconsin, and I had to get. Yeah, I'm sorry. I don't know. Yeah, that one's not working. So pardon me? I couldn't hear you. Yeah. All right, I'll put a little closer. In any case, what I had to do was get a letter from DePaul, and they told Wisconsin that the title had changed. But the most embarrassing part was I went on a morning like this, and we had to go up in front of all the 7 justices of the Supreme Court of Wisconsin to get sworn in. And I was pushing so hard in my car that all of a sudden my pants ripped in the back. All right, so the justices are up there looking, and the moms and dads are down there. And they had one of those really big books where you have to write in the books that you save everything. You know what I'm talking about, a big book. And when I went over to sign up the book, the page moved around and the woman said, why don't you just use your other hand? I was going like this. And she thought I was a jerk because I said, would you please hold the page yourself? So I did it. But that's how you, at least in those 2 states, in DC, you have to be, it's right.
I'm trying to understand something. If you are a licensed judge in both Wisconsin and Illinois, how do you make a decision of where you're going to try it? Do you have to move to Chicago or move to Illinois to work here? You can't work as an Illinois judge if you're living in Wisconsin.
I did 200 cases in Wisconsin for low-income people who didn't have a lawyer. I was appointed. They have 2 different systems. In Illinois, the public defenders are all members of the American Federation of State, County, and Municipal Employees. I said, just hold that thought for a minute. That's the union. The public defenders in Wisconsin are members of the American Federation of Teachers, which is a liberal New York teachers union. They organize the lawyers in Wisconsin. So they see life differently. When I was 50 and I wanted to do criminal law, but I couldn't find anybody to supervise me because the 30-year-old lawyers didn't want to supervise somebody who was 50. It didn't feel right to them. So I went to the public defender's office in Illinois and said, I'd like to work for free. And they said, you want to take one of our labor union jobs? I said, no. Well, if you do the work, then we will have one job that we can't fill. Okay, so I couldn't do that. So I went to Wisconsin, and the union there for their members wants people to leave at 5, not 5:01, but at 5 and go out and look at the sunset or whatever they want to do, or go home and take care of their kids. So they have a very robust system of having lectures like this where they train the people, which doesn't happen in Illinois because just the 100 or 200, 300 public defenders, they get the training. But in Wisconsin, they had so many green lawyers, including me in the beginning, that they have to have a big lecture hall and train people. So I did that. And then they would say, hey, Cohen, you in the back of the room, you got this next case because this public defender's got enough cases. So they paid us about $40 an hour, which is just enough to have our gas money to go up there. But Wisconsin does not have a residency requirement, in answer to your question. Indiana does. So if you were an Indiana and an Illinois lawyer and you are down in the bottom part of Chicago, you go 1 block into Indiana, you can't practice there, even though you have a license, unless you have a residence there. Each state can make up its own rules. I hope I've answered your question.
You've confused me more.
The answer is, as lawyers like to say, it depends.
Different rules for different states.
For different states, right? California and Arizona, you've got to take the exam. Wisconsin and DC, you don't have to take the exam.
Yeah, a quick question. To become a licensed patent attorney or trademark attorney, you have to take a special bar exam.
That is true.
And are there many other areas of law that's required?
I didn't quite hear the question.
Are there any other licensure, like in Illinois, besides the
yes,
the bar for being an attorney, besides being intellectual property attorney?
Intellectual property lawyers, if they want to do trademarks and that kind of work, copyright, they have to take extra training. Many of the lawyers who do copyright work or intellectual property years, so they can understand your great invention. There's another group that has to have extra training, and that is who go in front of the tax court and argue why you should get the money back from the IRS. Well, that's another area too that's different. And you saw on the one page there that the number 13, the Federal Circuit, they have nationwide jurisdiction over specific case types, including patent law, trademark, and certain other cases. So you're absolutely correct. I'm glad you mentioned that.
Does an attorney have to have any? Does an attorney have to have any special qualifications to argue before the Supreme Court in Washington, D.C.?
The question is, do you have to have special qualifications to be in front of the Supreme Court? And the answer is, it's like your question here. I can practice in front of the Supreme Court, and I had to have a friend of mine, my roommate in law school, write and recommend me. And then they saw that I was licensed in one of the states or in the District of Columbia or Puerto Rico, and I was waived in. So the answer is you don't really have to have any other expertise. And in the Supreme Court, can't normally see it, but there are chairs like this, and up here are the benches in front of the Supreme Court. This is where the trial lawyers are who argue the cases, but back here are chairs like in this room, and that's where the lawyers who are admitted to the Supreme Court sit behind the and the press is along the side. So but you have to apply.
John Roberts said that there's too many selections of circuit courts for like tort cases. You go to this court, this county because they have a better jury system, or they have a better, they think they'll get a better response. Or is there some way of stopping that or doing that? Like
This-
for a tort or for.
The question is about going to forum shopping, looking for a district where you can file your suit. If you have an automobile accident, normally the case would be where the accident occurred, but you could also, depending on the state, have file it in the accident where you in this jurisdiction where you live. So if your accident was in Texas, you could file it there, or if you thought that the juries in Cook County, assuming you live in Cook County, would be better for you, you could file here, but you couldn't file it in Pennsylvania, you couldn't file it in Colorado, and unless somebody in your car was from those states. So you have to look at the venue laws or where you're going to have that. So there are some restrictions, but if you have a case that of an airplane that goes down lots of different states, you can file in, depending on the state, you can file in each one of the places where the injured party lived. And so sometimes that allows the problem that you were saying, that people can forum shop or decide which one they think is better.
Okay, we've kind of run out of time. Thank you very much. We appreciate you being with us.
Thank you.
Very excellent